Everybody knows Casey Anthony, the defendant in Florida who was acquitted in the death of her daughter, Kaylee. Well, she may wind up in a courtroom again. Not on that charge, of course, that would be violating double jeopardy, but on another charge. This is a civil case, a defamation claim. Howard Marks is an attorney in Orlando, Florida. He's joining us now live on the Law and Crime Network. Howard, good to see you here on Law and Crime.
Good to see you, sir.
Okay, you represent Ray Kronks, who was the man who had the unfortunate duty in life of finding the body of little Kaylee Anthony. That must stick with him, it must bother him, and it must bother him in more ways than one, because now he, through you, has filed this defamation claim. Is it accurate to say that this is just a circumstance that has stuck with your client in more ways than one for quite some time?
Absolutely. He was doing what he thought was a public duty, the right thing. He reported what he saw several times, and as a result of that, he became plastered across the papers and the press throughout the United States. We believe from a concentrated, orchestrated effort to point fingers at him, like from Casey Anthony and her attorneys, that he was a murderer, a kidnapper, everything to a pedophile, and just destroyed his name and reputation. And so he's been attempting to get some redress against Casey Anthony. And during the civil case in Orlando, when she filed bankruptcy, it gets stopped and removed to the bankruptcy court.
Yeah, so let's break this all down here, because there are a lot of moving parts legally. So defamation, of course, is what you're alleging here. It's a false statement of fact of and concerning another person, in this case your client, Ray Kronks, made without privilege and spoken or published to another person. Those are the basic elements of the claim. So exactly what is the defamation here, according to your case?
Of course, in Florida, like most states, statements that are made inside a courtroom are privileged. But there was an orchestrated effort here. Even when we took the deposition of Casey Anthony, she admitted that they went out in the public to distract attention from her, to accuse my client of being the murderer and accuse my client of being complicit in the death and the tragic death of her daughter. And she did that through her agents, attorneys, and a variety of people. And that is not privileged, and that is actionable. She knew about it. She approved it. She didn't stop it. And we're asserting that she should be held responsible for that.
So she had a right, you're admitting, to basically present this defense and point the finger at your client in court. The issue you have is that the campaign went outside the courtroom and into a lot of national publications and television shows.
Well, she had a legal right, a privilege to do it in court without having any civil liability. I still think it was an improper thing to do in this case. Obviously, if you're on trial for your life, you try to do everything you can to try and save your life and get a defense verdict. But in this case, that was not even their strategy. That was not even what they were ultimately, when they got to court, complaining about. They admitted that the child died in a pool, whether it was accidental or not. So there was no reason to go ahead and point the finger at my client as the person who committed the murder, when they knew all along that their position was that the poor child had died in a swimming pool. That was in their position at trial. And so to come out and to deflect against my client falsehoods, we believe was inappropriate. And clearly they're liable when it's not done in a court of law. So
that's the core claim here. You're saying that there's no privilege. If they had done it in court, the privilege would attach under Florida law, but because they did it outside court, no privilege. I want to break that down a little bit later on, but first, is there a chance you're going to sit down and depose Casey Anthony? Are you going to ask her questions?
I've already deposed Casey Anthony in this case.
You will?
And yeah, I already have. I mean, the judge has permitted me to depose her, and mostly it was Fifth Amendment issues, and mostly she wouldn't answer any questions, which is fine. In a civil case, if she's going to take the Fifth Amendment, then there's certain presumptions that are standing under Florida law that is against her. And if she doesn't want to state anything in the civil claim, that's fine, but that's going to come back to haunt her if we can get our day in court and if we can get this thing to trial.
Was that a deposition? Forgive me, I thought that there were some interrogatories. In other words, you were sending written questions back and forth, and she punted on those. But she won't sit down and talk either.
Oh, we ultimately got her to a deposition, but she didn't give much information in that either. Okay. At the present time, Casey Anthony has discharged every claim against her. The last person standing that has any chance to make a claim against Miss Anthony is Mr. Krog. And one of his main purposes here is he does not want her to profit of the tragic death of her child. The bankruptcy court has allowed her to buy her own story. So if the discharge actually takes place, she can go out and sell her story for millions of dollars or whatever it is and keep all the money. The last person that could stop that from happening is if Mr. Krog can get his day in court in judgment. And again, under Florida law and under the bankruptcy law, not only do we have to have a judgment, but the court has to determine it was a willful and malicious injury, so it is not dischargeable in bankruptcy court. And that's what we're attempting to do, to get a day in court to try and prove that.
What's your opinion as to whether or not this is going to go to trial? Is there a chance you're going to get her up on the witness stand to basically tell you nothing, which has been what she's told you thus far?
Well, she's going to sit in front of a jury and tell nothing. That's going to be at her own risk. I mean, that's what we've been attempting to do for the last few years. What the bankruptcy court has tried to do was determine whether or not legally there's going to be a willful and malicious injury, even if we're true. And if the court determines that, we should get our day in trial. If the court determines, which we believe would be incorrect, that even if everything we say is correct, it's not willful, and it was not, purposeful, then, the bankruptcy court, even if we went to court, could discharge a judgment against her. So we're waiting now for a bankruptcy court determination on whether or not we can proceed against Casey Anthony in a civil case in Orange County is where we're trying to get the case back to. We don't believe the bankruptcy court has authority to hear that part of the case.
Yeah, I wanted to dig into that a little bit more here. So you've got a defamation claim, which is state law, and it's wrapped up in this federal bankruptcy claim. Can you unravel that ball of twine a little bit more for us?
Well, typically how this happens, if you have a state law claim and the bankruptcy is filed, it stops the state law action, and you have to deal with bankruptcy court, usually getting a relief from bankruptcy court to try the state law claim, and then you go back to bankruptcy to determine whether or not it's dischargeable under the bankruptcy code. In this case, it's getting a little complicated, but in this case, the judge has kind of reversed that procedure and said and now it's a she, the judge wanted to make a determination whether or not it was dischargeable before we even had to put on our case. And so that's what we've been waiting for, determination one way or the other, how the court will ultimately proceed with it. We have asked over and over and again, have a recent motion again for the bankruptcy court to abstain from hearing any of this and allow us to go back to state law, to state court to try our case.
And you think that
what we want to do.
And you think that you've got a shot there in state court?
Oh, absolutely. If we get our day in trial, we have a very good shot. We're just trying to get our day in trial.
So if you get Casey Anthony up on the witness stand and she's under oath and she sits there in front of a judge and a jury, what is it that you want her to say?
I want her to say, which part of it she's already said, that there was an orchestrated attempt. She knew my client was not the murderer. She knew my client was not complicit in anything to do with the child's death. And as a result of her charges, her and attorneys got together and made a decision to defame my client, destroy his reputation, solely to deflect whatever guilt she may have onto Mr. Crumb. That is, to me, an outrageous act. It's an act that was not necessary because it was not even her defense. And she basically destroyed the reputation of a man that was doing nothing but reporting what he believed to be the remains of an individual, which turned out to be her daughter. And it's, it became a nightmare for my client, and it's very difficult for him to deal with. And he would like to get his day in court, and he wants to make sure that Miss Anthony does not profit down the road from the tragic death of her daughter.
And what's your assessment as to the chance that you think you've got to get her to admit all of those things?
Whether she'll admit it or not, she's admitted under oath that she understood that people, including her lawyers that she approved, were out there to deflect guilt from her onto others. She admits that. There's no doubt that she knows the comments that were made by her agents and that they were defamatory, certainly against Mr. Crump. And that is our story. We're not asking her to admit whether she killed the child or not killed the child. That is not ultimately our story that we're going to get her on court, get her on the stand for. We want her to acknowledge that she went out on an orchestrated and concentrated effort to destroy my client's reputation solely as publicity and to deflect guilt from herself. That is defamation.
You have a lot of other people named in this case as being part of this orchestration. You've got Jose Baez, you've got Linda Kenny Bodden, you've got Mason Chaney, you've got the original defense team and everything. Had you thought about going after them?
Well, there's been lots of thoughts, but under the law, we believe the most appropriate defendant in this case was Casey Anthony, and she's the one that Mr. Crump is most concerned about, that to hold liable for the comments that were made that she's ultimately responsible for, and we want to make sure, again, we get our day in court and she doesn't profit, and that's what Mr. Crump is looking for.
Two more questions for you, Attorney Marks. One is this one. A previous defamation case against Casey Anthony basically went nowhere. It had been filed by her babysitter. What makes this one different? Why does this one have legs?
Well, that one was a totally different set of circumstances. Apparently, there was a comment to the mother when she was in jail, and the mother commented to somebody that was not even a determination on whether or not that plaintiff, which I think Gonzalez, was even the person that Casey Anthony was talking about. It's a totally separate case that went nowhere. There's clearly not a dispute here that my client was attacked, that my client was accused of murder, that my client was accused of kidnapping. She doesn't deny that happened. She just doesn't want to be held responsible for it. So it's a totally different animal.
And one last question for you. Your client, Ray Kronks, you said that he suffered with this. You know, I have to ask this question just to wrap up. A lot of people around America have a lot of opinions about Casey Anthony herself. If I had your client here in this interview, what would he say about Casey Anthony?
Well, I'm going to, at the moment, since there's still pending litigation, he's not talking, but at some point, when this is over, he'll tell his story. He'll be happy to answer that question, but I don't want to answer that question for him, okay?
We will put that to the next interview here on the Law and Crime Network then. We look forward to hearing him say that. So Howard Marks joining us from Orlando, Florida, representing one of the witnesses in the Casey Anthony case, Ray Kronks. We appreciate you joining us.